Good morning, and thank you for coming this morning. Yesterday was summer, and I guess fall is today, right? So this morning, we're going to have a conversation, talk about estate planning, which I had a lot of questions about with clients with regard to what's the best thing to set up. Is a trust better than a will, and that for it. So we're going to go through just basically a program here to help you understand a little bit more why titling is important. So, titling doesn't matter until it matters, and then it's too late, right? So it's important to make sure that assets are titled appropriately. We'll talk about the different estate documents and that you may need, and who needs to have an estate plan and that for it. So we'll go through all of that this morning here for us. So what is an estate plan? An estate plan is a map. So it's basically your map to take care of what you want to do. The map reflects the way you want your personal and financial affairs to be handled. All right? So it's very important to make sure that you have everything in place to be able to do what it is that you want to be done at the point in time when you want it to be done. All right? So who needs an estate plan? Chances are you do. So it's not just for the wealthy. And there is a difference between a will and a trust. We'll talk about that in a moment too for it, right? Without an estate plan, you can't control what happens to your property. If you die, you become incapacitated. So if you die, you do not have a will. You die what's called intestate. And if you don't decide where you want your assets to go, the state of Illinois will. Right? And they may not go necessarily to the people that you want them to go to. Right? So it's important that you have the right documents in there for it. An estate plan makes your wishes clear and avoids family disputes. All right? So one of the best things my parents ever did for me after they passed, they had included in their will what's called a non-contestability clause, which says that the person has the right to contest the will, but if they contest the will and they lose, they're out. They don't get anything, right? So it keeps people quiet who otherwise might not be. And having gone through this for a period of time, it always seems like the person that you expect to have the least problems with is always the person that you have the most. Not saying it be your case, it just seems what happens over the years in that for it. So you especially need it if your spouse is uncomfortable with dealing with financial matters. So if your spouse is not comfortable with handling financial or hasn't handled those matters for it, having the right plan in place will make sure, that what you want done gets done, right? And it'll give a roadmap again for that person to be able to conduct business and that for it. If you have minor children, you want to make sure they're taken care of, or grandchildren for it. If your net worth exceeds the $11.2 million, and now that's grandfathered for two people and that for it, and you own property in more than one state. So if you own property, let's say in Illinois, and then let's say you have a winter home in Arizona or that for it, if those properties are not titled correctly, you could potentially have probate in one or both states, right? Because Illinois probates, it doesn't mean that Arizona is necessarily going to take what Illinois says and that for it, right? So you can prevent problems from occurring at that point for it. Also, if financial privacy is a concern. So a will is a public document. So you ever wonder, like, they find out, Johnny Carson, why he left, $1 million to his, nanny or, mistress or whatever, right? It's not a big problem. All they have to do is go down to the courthouse once the will is filed. It's public information, and they can pull it all out. So your neighbor, if they wanted to, something happens to you, they could go down to the courthouse, and they could pull up your will, and they say, okay, who's going to get what and that for it, right? So that may or may not be what you want. Right? So if you want it to be kept private, then you have to have certain documents and certain things in place to make sure that your privacy is kept intact in that for it. And the privacy may not only be for your neighbors, it may be for your family members as well, right? You may not want your family members to know that some money is going to one person. Someone may think they are entitled to more, and it's your money, so you can give it to whoever you want. But you want to make sure that it goes to exactly the people that you want it to go to without any disputes of that for it. If you own a business or that for it, that's also important to make sure that the titling in that is appropriate for it. So you have incapacity, health care, property management, planning for death, wills and probate, basic taxes, and lifetime giving are all part of your estate plan for it. So does everybody know what the gifting limit is for 2018? It's $15,000. So you can give anybody you want $15,000. You don't have to file gift taxes, and it's not a reduction in unified tax credit. If you give more than that amount to someone, then you will either pay taxes on it, gift taxes, if it's over that amount, or B, you can have your accountant file an extension or something for a unified tax credit reduction, and therefore it would be reduced so you wouldn't have to pay any potential taxes along those lines for it. So if it's a married couple, you obviously can give $30,000, $15,000 per person. So husband and wife can give a son or daughter $30,000. They could give all their kids $30,000 if they wanted to. All right. Not saying they want to, but yes.
I'm sorry to interrupt, but when you said gift, when you talk about the gift, is that for the giver? Is that a tax deduction?
No, there's no tax deduction for it. If you give more than the $15,000, though, there are potential gift taxes, right? So, but it's $15,000 per person. So again, a husband and wife can give $30,000 to their child if they want. So if your son or daughter were buying a house and you wanted to give them, so to speak, a down payment for it, you could write it. You could write a check. Your wife could write a check. There's $30,000. They could deposit it into the account. You could also give $30,000 to the spouse if you wanted to, so they could essentially get $60,000, right? If you wanted to. Not saying you do, but if you did, right? That's part of it. So, not unless you want to own another house, it's just giving them the down payment maybe for the house, right? So, but that is important because if you don't, then there are potential issues that could come, through it for it. The other area is planning for incapacity, right? So incapacity can strike anyone at any time. Today, it's not necessarily a physical incapacity. More and more people are having mental illnesses, dementia, Alzheimer's, and that for it. Especially with those, you have to make sure you have documents ahead of time, because if there's problems and they're not done appropriately, then there could be potential issues with the validity of those particular powers of attorney and that for it. So, and a lot of people think dementia or Alzheimer's, that is for quote-unquote older people. It is not. I mean, there are people who are in their 50s and 60s who are having mental issues with recognition and that for it. So it's not just something that as we necessarily age, that is something that affects us. It could affect anyone at any point in time. All right? And it's important to have the right documents. Failing to plan means the court could potentially appoint a guardian. So if you don't have the right documents in place for it and nobody can access maybe financial assets or that for it, then the next step is to get a court-appointed guardian for it. And that's not, it's expensive to get the guardianship, but also you have to provide the court documents, usually on an annual basis, to show that the money that's being spent, that's coming out of these accounts and that for it, is being used for the care of the person that you are now the guardian for, right? So you have to get attorneys involved, and those could be expensive and that for it. You have to go to court, which could be expensive and that for it. You may have restrictions on things that you can access or that you can do and that for it, and you have to have an accountability to someone. That may or may not be a bad thing for it, but it does add up to the cost and may not do exactly what you want to have done for it, right? Lacking of a plan increases the burden on your guardian, and your guardian's decisions, again, may not be what you want to have done, right? So it's important that you have the right documents, because if you don't, then, again, your wishes may not be executed at the point in time when they need to be in that part, right? So, and especially becomes true if you know anybody has like a business or that for it. If you have a business, I mean, you want to make sure that business continues, right? So if there's a continuity that goes along with it, how does that get established, right? Do businesses do buy-sell agreements? So if you have a business, you can do a buy-sell agreement that if something happens to me, this person would buy this person out. Not only from a death situation, but also from an incapacity situation. So a lot of times if someone becomes disabled and that for it, well, if they're the main person in the business and that for it, how does that continue? They still expect to maybe continue to get paid, but how are they going to do so if they can't work and can't do that? So sometimes disability policies that are for businesses to help people flow through and work through those situations is important for it. So planning for incapacity, there's basically healthcare directives. A living will puts your instructions in writing, right? It's always good to have something in writing, right? Because when you go to the hospital or that for it, they want to make sure that somebody is getting information that they're allowed to give it out to for it. A durable power of attorney for healthcare proxy, lets you designate the agent to make decisions on your behalf. And the last one really is on a do not resuscitate order, a DNR. So a DNR basically saying that to do not resuscitate, if something happens and it's meant to be, then just kind of let it happen at that point for it. When you go to the hospital and you are a power of attorney. So my uncle, when he would go to the hospital and therefore I was his healthcare power for it. I always recommend, if you are a healthcare power, to make a copy of the healthcare power and keep a copy in your glove box. The reason for it is if you get the call in the middle of the night that you have to go somewhere for that for it, you're not most likely going to be going, where are those documents that I need to grab to take to the hospital to make sure I can get the information? It's going to be, where are my car keys, where's my wallet, and where's my coat, right? I mean, those are pretty much what you're looking for. So, but if you have a copy of the healthcare power in your glove box for it, well, if you're driving to the hospital, the worst thing that may happen is you have to go back out to the car to get the papers to be able to bring back in for it. And hospitals they may keep track of it, but it's only on a per situation. So if you go in the hospital today, or the person goes in today and then they don't go back for 2 months and that for it, the power of attorney that you brought in 2 months ago, not saying it's not valid, but they don't necessarily have it uploaded into the person's chart for that for it. So you need that power of attorney every time you go into the hospital because they don't know who to talk to. And because of privacy rules today in that for it, they're not allowed to give anything out. So unless you're in the room with the person, or the person directs and says, you know, I want my niece or my nephew or my wife or whatever to get this information, the hospital by law is restricted as to what they can tell. So that's important because if you're the person that's going to be responsible and have to make these decisions now for it, you need to make sure that you're in a situation where you have all of the information with which to make the decision. Because if you don't, then how do you ever know what's going on for it? So whenever I would go in, I would bring in my power of attorney. I'd say I'm his nephew, I'm his power of attorney. They'd be like, well, we can't show you anything. I'd pull out my power of attorney, and then they'd be like, okay, thank you very much. They'd scan it, put it in the system, and I could get all the information, not only from them, but from the physicians and that I wanted to. So not only is it for the hospital, but it's also maybe for the physician. So if you're going to the doctor and that for it, and you want to be able to get information on something, you need to make sure that you have the document, because again, it's restricted portion for it, and it's a privacy issue. If they provide information that they're not supposed to or allowed to, they could potentially be sued, right? So everybody's trying to make sure that that doesn't happen for it. They want to make sure that they're in a situation where they're in control and that you've got everything set up the way you want it to be set up, right? If you plan for incapacity property management tools, joint ownership. So there's joint ownership allows the same access to an account. If you have a joint ownership and you put a child on it, be aware that child has the same access to the account that you do, right? It also opens up the potential issue if they were to get sued or a marital situation dissolves, and therefore it, they could potentially go after half of that asset if it's sizable enough, because their name is a joint owner on the account. And as a joint owner, they legally are entitled to half of it, right? So there are basically two types of joint ownership. You could have joint tenants with rights of survivorship, which means that if something happens to one owner, all of the other ownership passes on to the next owner. So if it's myself and my wife, something happens to me, my wife automatically gets the account. Then there's what's called joint tenants in common. Tenants in common basically means whatever each of us bring into the account it goes to our respective estates. So let's say I bring $50,000 in, my wife brings $50,000, there's $100,000 in the account. Something happens to me, the $50,000 doesn't necessarily go to her. It goes according to who I say in my estate would go to, right? So maybe I want it to go to my kids and not to her, right? So it's joint tenants in common. It follows the bloodline as opposed to becoming just one property. right? Yes?
If you could digress 1 second, you were saying that how things are titled in terms of joint ownership.
Yes.
I was taking out saving bonds for my kids when they were young, right?
Okay.
Okay.
So they weren't joint owners, they were payable on death or a minor ownership.
Right. I was on there.
And then they were a minor.
Me and then I think it's Orland.
Okay.
Myself and my child.
Okay.
So he gets married.
Right.
You telling me that if she files a divorce, she is eligible for 50% of his 50%?
Potentially. Because it's because of an ownership. So that situation is an or, not an and. So there's a difference. It's you or him, not you and him. Right? So see the difference in there? And means both of you. Or means either me or him, not both. So that's why titling is important on the accounts, because if they're not titled appropriately, things can happen, right? So just as an aside, all of you have probably a checking account, right? Do you have a beneficiary on the account? So if something were to happen on that account to you, where would those proceeds, how would anybody get access to those proceeds? They couldn't, immediately anyway. I mean, eventually they could be potentially, if they had go to court and they had to go through probate, or they got letters of office or that for it, right? But from an immediate transfer, you can't do that, right? Yes?
Milton, does that apply to real estate?
Correct.
And or
Correct.
ownership?
Right, because it's
Okay.
and both of us, or me, or
Okay, I
you,
see.
right? And if I'm primary, then I'm first and you're secondary.
But still, buyer and co-buyer, it's still and or.
Can be, depends on how it's titled.
How it's titled.
Right. That's why the titling is good. So it could be joint tenants in common, where if something happens to me, my share goes to my family. If something happens to you, your share goes to your family. Right.
Okay.
So that's why it's important to understand how it is, especially in businesses, because if you have a business and it's a joint tenants in common, do you want your business partner's spouse maybe as your new partner? Maybe you do. Maybe you don't. Right. So that's why it's important to understand it, because these all come into play on how everything is going to come along with it, right? So then you have a power of attorney. So if you do want to put someone on your account, not necessarily as an owner, but for your son or your daughter or someone to be able to access the information and maybe to be able to write checks out of your checking account, if you put them on as a power of attorney, then yes, then they can go on, they can write the checks legally, there's no fraud or anything, you've told the bank, they go in and sign the signature card for it. But if something were to happen to you, they cannot conduct any business because powers of attorney cease at death. Right? Power attorneys don't continue after that. There's no reason for them. Then it turns over to an estate issue at that point. Right? So again, understanding it, it also means that if they are working on your behalf, they are not an owner. Right? They are working on your behalf. Therefore, if something were to happen, marriage dissolution, or they get sued, they can't go after that money, because it's not there. They have no ownership interest in it. They are just there to conduct business, to make sure that things transgress and do what they want accordingly, right? And then you can have a trust. So you can have, there's different types of trust, but you can have a trust that can own the assets. A trust can own virtually anything. It can own your car, it can own your house, it can own property in 2 states, right? So in my example, if you owned a house here in Illinois and a house in Arizona, they're both titled in the trust. If something happens, the ownership belongs to the trust. The trust then will distribute the assets according to how they're supposed to go without any probate. You don't have to go through probate, and it's a private transaction. So you don't have to go to court and tell everybody who's getting the beneficiary, what's happening in the trust. The trust is private. All right, so it becomes a living trust while you're here. Excuse me, and then it becomes a testamentary trust when you pass. But it's now a testament to what you want. Once it becomes a testamentary trust, then it becomes irrevocable. Nothing can be changed in there, right? Because the only person that could change it would be the owner or the trustee of the trust at that point, right? So it lets a successor take over. So if you're the trustee right now and something happens to you, then the successor trustee basically steps into that trustee position, right? A lot of clients will ask me, do you think you should have co-trustees? Well, it's kind of like having two presidents, right? If both people have power, and let's say we get everything set up in the trust and therefore one person calls me and says, you know, you should sell this for it, I execute that, the other person calls me and says you shouldn't be doing that, who do I take direction from? Right now I've got two people that are telling me two different things, and both of them have the legal authority with which to do so. Sometimes it can be set up where they have to agree on it. So while both people may have authority, they only have authority up to their portion, and they're only 50%. You need to get 100% in order for it to be executed. So there's different ways to write your trust. If you have a special needs child, you can potentially write a special needs trust in there for it, so assets can flow into the special needs so that they can be there for the child's use in that for it. So there's a lot of issues, a lot of ways you can structure a trust in that for it. Basically, I define a trust as either a legacy trust or as maybe a divide and conquer. Divide and conquer is just basically sell everything, put it into trust, and sell it out. It's done, it closes, and it finishes. A legacy trust could be a trust whereby you want your assets to be distributed over a period of time. All right? So maybe it's over a 5-year or 10-year period of time. Or maybe it's to make sure if something happens to you, it goes to your kids, and then it goes to your grandkids for that for, right? Maybe it's you want it to go to your son or your daughter, but maybe you're not very fond of their husband or wife, so you say, okay, I don't want it to go to that person, I want their share if something happens to them to go to either their kids or my son or my daughter, whichever it would be, right? So there's different ways that you can write it, but before you sit down with the attorney, it's important that you have the answer to these questions, because if you don't, the attorney's got an hourglass, right? That hourglass is going to run, right? The longer you sit there and want to have just kind of a general conversation about, well, what do you think is good? How's the weather outside? All that for it, that's fine, but just know that you're going to pay for that time, right? So if you walk in, though, and say, this is what I want, and therefore this is how I want it to be structured, he now has a template, or she has a template with which to work with to be able to now say, okay, well, this is what you want here, this is how I'm going to structure this. You know what you want. He knows the legal words to put into place to make sure that whatever it is that you wanted legally can happen and occur, right? So that's why it's important to make sure before you go and sit with the attorney, you actually have an outline of an attorney of what you want. You don't want to walk in and when the attorney says, well, why are you here today? And you say, well, I know I need a will and I think I need a trust and some powers of attorney and that stuff. And basically what they'll do is they'll go, okay, well, what do you want to happen? I want it to go to my kids or my grandkids or that for it. And unless you have thought through and done kind of a long-term discussion,